on Shabazz. No, I'm sorry, Tripp. I'll do Tripp first, because did you tell me Tripp was ready earlier?
Yes, Your Honor.
I'm ready on Tripp. And what are we doing on Watson Wilson? Am I coming down for a trial?
We have a resolution, Your Honor, PTR. We're in receipt of what we want.
Okay, this is case number 244438701. The People versus Christopher. Might be Lorenzo is cut off on the docket. Tripp, defendant is charged with child abuse 4th degree. Today is the date set for final pretrial conference appearances, please.
Morning, Your Honor. Alex Hill on behalf of the people.
Here, Mr. Tripp will continue, Dennis Stevenson on behalf of Christopher Tripp. Mr. Tripp, please say your first, middle, and last names.
Christopher Lorenzo Tripp.
All right, Ms. Stevenson, how are you proceeding? Because you was getting ready to tell us.
Right, Mr. Tripp is going to continue his plea of not guilty, but I would ask for sidebar with the court and the people.
Right now?
This might help.
So that means you all want me to come downstairs because Mr. Hill is not on this thing?
But he and Miss Coleman, they'd come in here or something.
Okay.
Okay, thank you, Your Honor. We're gonna go into the room right now.
All right, come into the room.
Thank you, guys. Thank you for your patience.
Then I guess we need to go to breakout. Wouldn't it be funny if we just started talking right here? Join me in breakout room number 1.
If you didn't know, y'all stink. Okay, that's just my opinion.
All right, back on the record with the People versus Christopher Tripp.
I'm on it.
Oh, I got
Man, I'm only gonna let you talk to him for about another minute.
Okay, Your Honor, thank you very much for that, Grace. Trying to just figure out how Mr. Tripp can help the people to have a conversation with the complaining witness's mother.
Oh, well, I'm gonna tell you how we're gonna have a conversation with him. If she don't answer the phone the next time, if she doesn't respond to that text the next time, I'm gonna send the police out there. I'm gonna send the police to the child's school. And then we're going to take care, custody, and control over the child. And then they'll have to get the child from protective services. So let me be clear. Let me be clear out of my mouth. Let me be clear. If Mr. Tripp resides with the mother, then he better go home and tell her that she better answer Mr. Hill's phone call. She better respond to his text, and she better produce my witness, because failure to do so is going to cause me to show cause her, and I'm going to have her arrested. Listen to me clearly and carefully. I'm going to have her arrested, and I'm talking about the mother of the child. Whoever has care, custody, and control over the child, they had better produce the child to Mr. Hill. They had better produce the child to Mr. Hill. Stop talking. Stop talking. Whoever has care, custody, and control of the minor witness had better produce the witness to Mr. Hill. Failure to do so is going to result in me contacting protective services, in me issuing an arrest warrant for interference with this criminal prosecution. It is going to result in charges for witness tampering. Listen to me carefully and clear. I'm not playing. Now, the case can be resolved, and I will entertain pretrial resolutions, which will include in-person classes. But what I will not do is allow some person to bully this court system. It's never going to happen. The bullying of this court system, it's never going to happen. So whoever has the child, I know the baby got a cell phone. It's 2025. But what I also know is that she's in school. She's in school. Either she being homeschooled and that address has to be registered with the state, or she's in a physical school. And she's going to talk to Mr. Hill. The witness is going to talk to Mr. Hill. And if the mother has custody, they're going to produce the child. If Mr. Tripp has custody, he's going to produce the child. Whoever fails or refuses to produce the child, I'm going to have those charges issued against them. And
The wheels of justice are going to roll you right into the Wayne County Jail.
we're going to have a warrant for their arrest. All right. Now, any further
Wait, I'm still not clear. Do they need to produce the child?
facilitation, that's y'all business. If Mr. Hill comes back here and tell me that they still not answering his calls, he can't find his witness, this minor witness, it's going to be somebody is going to have to deal with that, and they're going to have to deal with me. Anything else before I get a date?
Thank you, Your Honor. Nothing by the people, prisoner.
So for the date, Your Honor, in that, we would have to be able to arrange the in-person classes.
Sounds like the whole family needs some classes, but I can't make the other people go to class. Does Mr. Tripp work?
Not at this time, Your Honor.
Oh, well, then he could go to the classes. But I don't know where the in-person classes are. You know, I'd be thinking Mr. Rice can do anything. I feel like he has all the classes, but those may not be free, so I do understand that. I'm not opposed to it. Maybe you need to get a referral from probation,
Okay.
but yeah. And I am live streaming right now. So if you want to go back and play this for her, you can go back and play this for her. If you don't have if somebody don't have they don't want to say it with as much fervor as I'm saying it, the video is going to be there. You just show her, this is what the judge said. And I mean it from the complete bottom of my heart. I mean it. I mean it. I mean it because I feel like she's trying to bully the system. And
I think she means it. I'm taking the judge at her word on this one.
trying to whatever. And I'm not going to have it. I'm not going to have it. Okay. So let's do this. And I want at least 6 classes in order for me to accept the pretrial resolution. What I'm saying is, Tripp, you can't listen to her, talk to her, and listen to me at the same time.
Just explain to her, I have seizures and right now I feel like I'm having a panic right now. I have medical issues for it.
Now, you're not going to make me put you in the Wayne County Jail and mark your file medical.
Anxiety leads to constipation.
No,
Okay, well, take a deep breath. We're going to take a deep breath. If you need some water, they can give you some water. But let me say this to you. You can take a deep breath. And if you need some water, they can give you some water because court is stressful. And if the stress is going to trigger whatever you're having, then we're going to need to get you some medical attention. All right. I'm gonna set it for at least 6 weeks, 8 weeks out, because I want 6 classes in order for me to entertain the pretrial resolution.
Okay.
So I could put it October 29th, but I won't. I will put it. Oh, I can't put it. Oh, I could put it. I think I could put it. Let me see what time I'm on. Right, leave. I could put it November let me see. Mm, that might not work. That's 12/25. That means I could put it November the 3rd. Yeah, I'll put it November the 3rd. For final pretrial conference. And then I'm gonna go ahead and put it on my trial docket as well, November 3rd. And so then I'm gonna put it on the trial docket for December 2nd. So let's put November 3rd at 9:10. And then I'm gonna put it for a jury trial. December 2nd. And know that it is first in priority. That's why I put it on the 2nd to make sure. And that's at 9:30. So if the matter doesn't resolve, oh, I keep looking, this is TRIP. And this is MFD. And that, all right. And then I won't have to lock nobody up while they wait in order to get the witness for the trial.
Do that. You gotta do that.
Anything further on behalf of the people?
No, Your Honor, thank you.
On behalf of the defense?
No, thank you, Your Honor.
All right, we're all set then. Everyone have a great day. Stay safe.
Thank you very much, Your Honor.
You're welcome.
All right, that's gonna be
Okay, we're gonna go to the SovCit for a live SovCit emergency. Let's do this thing, shall we?
That just doesn't change the court date. It does change. Mr. Black, can you come on the Zoom call?
Yeah, can you hear me?
I can.
Okay.
So this is on for pre-trial. So you don't have an attorney, is that correct?
I'm not sure I need one yet.
Okay.
Can I have your name? It says DC.
Your Honor, if I may, a couple of things.
Yeah.
But first of all, the state has received a supplemental report and is prepared to establish probable cause at this
Okay.
time. And then also, if the defendant is electing to go pro se, the state would request a pro se call.
Okay, I think that may have already happened. But in any case, so Mr. Blatt, right now, this is on for a pretrial, which is the opportunity for you and the state to discuss the case or maybe come to some sort of resolution. And then it can be, and right now it's set for trial. Otherwise, it would continue on to trial. Your trial confirmation is October 22nd. And then the trial itself would be October 29th and 30th. So I guess where do you said you don't think you need one, but which tells me that you don't have one at the moment. So I guess how do you see this case progressing and playing out?
Can I have your full name and the prosecutor's full name?
My name is Sam Meyer, and the prosecutor's name is Ms. Kidmacher.
Is it Meyer?
Yes.
And the prosecutor's name again is
Last name is Kidmacher.
okay. And first name?
It's Gabby.
Okay. And can I see your oaths of office and official bonding information?
Well, again, speaking only for myself, the answer to that is no. I don't have it on me. I don't carry around with me. I haven't. It's not necessary for me to post my bond. And, the person who needs to, I'd like to know some information from you as to where you see this case headed.
When the officer stopped me, if I were to tell him that I have a license, I have insurance, I just don't have it with me, I don't think that would cut it with him. It's important for a driver to have his license and insurance in order because operating a motor vehicle is a potentially hazardous occupation. The same is true with being a judge or a prosecutor. It's a potentially hazardous occupation because people could get hurt. They could go to jail unlawfully if something goes wrong. So a judge needs an oath of office, which is anomalous to a driver's license. And
Right.
The bond is equal to the insurance that a driver would need to have.
He wanted to say analogous.
So I do have a oath of office. It's good. The auditor's office, if you want to go there and get it, you can certainly look at it. But like I said, I don't carry it with me. I don't have it on the I don't have it posted on the wall. I don't believe I'm required to. You are required to have a driver's license when you drive a car. But I don't, we're going down a rabbit hole, which really isn't that productive for you, Mr. Blatt. I'm trying to figure out, where you see this case headed. And it's either going to be set for trial or there's going to be some sort of resolution. And if you think you've identified some issues with me or you haven't seen my oath of office, if that's an issue on appeal you want to raise, if you get convicted, you can certainly do that. But we're not going to spend a lot of time on, things that don't really matter with regard to your case. You might not believe that it doesn't matter, but it really doesn't. Right now, you're the one charged with driving with license suspended in the 3rd degree. Your options are go forward to trial, which I've told you when that's scheduled on October 22nd for trial confirmation on October 29th and 30th. And that's kind of, so I guess I'd like some answers from you as to where you see this case headed.
Okay, you just said you don't want to spend a lot of time, but if the prosecutor wants to spend 3 months of my time in a jail, then you have to afford me the time I need to get due process. Now,
Yeah.
at the beginning of this Zoom hearing, I heard you say that the state is charging me, but the paperwork I've been giving says the city of Tumwater is charging me. Could we clarify that?
Yeah, I can clarify that. And that was the mistake on my part. You are correct. It is the city of Tumwater.
But the city of Tumwater is franchised by the state of Washington, right? And it's using Washington statutes to prosecute this case, right?
I don't know about the franchise aspect of it, but it is a municipal case from the city of Tumwater. A lot of times municipalities incorporate on criminal codes and misdemeanors, they'll incorporate the revised code of Washington into their municipality with the law within that municipality. So yes, it could very well be prosecuted under a statute from the revised code of Washington.
Well, that raises some concerns with me because I see to your left, you have the plaintiff's flag behind you. And so are you a neutral entity or are you part of the prosecution?
Yes, I'm a neutral entity. I like to think that, yes.
Then why do you have the prosecution's flag behind you?
It's not the prosecution's flag. It's the flag for there's a flag from the United States of America. There's a flag from the Washington state, and then there's a flag for the county. I am a Thurston County District Court judge. I elected and have jurisdiction within this county.
But the state of Washington enfranchises the city of Tumwater to prosecute people under its statutes, the state statutes. So
I don't agree with your terminology there in terms of what they franchise. If Tumwater is a municipality, they have some discretion as to how they can choose to enforce laws within their municipality. One of the ways they can do that, and they're not alone in this, a lot of cities do this. Not everybody. Lacey, for example, has their own municipal code, but Tumwater might not. They might adopt the RCW for things like driving with license suspended in the third degree, DUI, and misdemeanor and gross misdemeanor things and things of that sort. Of course, felonies obviously would be under the revised code of Washington, and that would go to Superior Court. But this is limited jurisdiction, and we only deal with misdemeanors and gross misdemeanors. We're contracted to provide court services for certain municipalities within Thurston County, including Tumwater, Lacey, and to name a couple, and that's why you're here. That's how you're here.
are you going to be the judge throughout all the hearings in this process?
I don't know. No, we have a rotating schedule and may or may not. I'm just the lucky one today.
Oh, this is going to put a burden on me to check all the judges' oaths of office and so on.
No, it's not at the end. And don't worry about that. Like I say, our oaths of office are on file, and you can go look at any of them anytime you want.
Okay, I've been given this paper by the court. It says criminal traffic.
Yes.
I'm very upset
Yes.
about being called a criminal. I'm not a criminal, and I want to clear my name, believe me.
Well, you haven't been convicted of this charge yet, but driving with license suspended in the third degree is a criminal charge. It's a simple misdemeanor. It carries with it a maximum penalty of 90 days in jail and $1,000 fine.
And
As
you're
a
guilty of
practical
sin.
matter, that would be highly unusual for anybody to receive that sort of jail time for a charge of this sort. But driving with license suspended is a criminal offense. It just is, and that was done by the legislature. And
Now, driving and traffic are commercial terms. I mean, you could check it in Black's Law Dictionary. And the police narrative says that I had a passenger in the car. Passenger is also a commercial term. And passenger, according to Black's Law Dictionary and extensive case law, says that it's a customer who pays you to transport him, which is basically trafficking. There's nothing in the police narrative that says that to support the presumption that I was engaged in any commerce or traffic. So the case should be dismissed on that basis.
no, that doesn't matter. If you get behind the wheel and drive a car, you need a license. And there are certain rules and there are certain things happen that can cause that license to get suspended. If it gets suspended and you get caught behind the wheel driving, and the state can prove it, then you would be found guilty. Those terms of, Black Law Dictionary, whether they call that a passenger or not, I'm not really sure, but the law that applies in this case, like I've told you before, is the revised code of Washington, which deals with licensing and when people can drive and when they're eligible to drive. So all those things you say about, and again, you might not believe me, but those things you talk about, whether it's a passenger, whether it's a commercial term, none of that matters. The only thing that matters is, were you driving and were you validly licensed, or was your license suspended? And that's it. That's what this case is about.
Sir, I was traveling, not driving. Driving is a commercial term.
Okay.
At the time, now I know anything I say can be used against me in court. I'm fully aware of
So
that.
hang on just a second. Well, it can, but you shouldn't admit that. If by traveling, you were in an automobile and conducting that by having an engine running and applying pressure to the gas and brake and turning the wheel, whether it's traveling or driving, that's kind of like, 6 of one, half dozen of the other.
Sir, I need to make something very clear at the very outset. I'm not going to deny that I was traveling in my private property automobile on the date in question. I'm not going to argue. I'm not going to fight with the prosecutor about what the prosecutor wants to fight about at trial.
Good. That'll make
my
it easy.
defense is going to be something completely different. Now, I noticed something on the website for the court. It says jury instructions or jury guide.
Okay, so hang on just a minute. Before we get there, can I take that to mean then that you wish to go to trial on this?
I wish to be left alone.
Okay, well, that's what everybody wants. But right now, where you are is you're charged with the crime of driving with license suspended in the 3rd degree. So again, went back to this before. Your options are either come to some sort of resolution with the city, or you're entitled to a jury trial. And then if you win, and you started mentioning, I want to stop you when you started saying things about jury instructions, and that means if you wish to go to trial, you can do that. And but we can have a different conversation about your ability to represent yourself, which you certainly have a right to do. But I need to create a record that you're doing that, knowingly and voluntarily with open eyes. The possibility is still in place to have an attorney appointed to represent you, but when we started this conversation, I'm not sure that I need one. Most people, when they're charged with any sort of criminal offense, and again, this is a criminal offense, they take advantage of when they're offered an attorney at little or no cost. But again, that's entirely up to you. But what I need from you is a decision point on how you want to handle this case. Either come to a resolution or go to trial. And if you go to trial, then we're gonna, which is fine. Trial dates are set. But we're going to have a conversation about a few things before we get to a jury instructions. So again, I need some input from you as to what you wish to do.
I only participate in fair trials, and I have concerns about whether I can get a fair trial in this court. Can I?
Okay. Well,
Now-
the trial, if it's a jury trial, the people who are going to determine your guilt or innocence will be 6 jurors who will be impaneled from the jury rolls within the county. And it'll be up to them.
There'll be 6 jurors and an alternate juror, right? So that's 7,
Yeah,
right?
typically, yes.
Well, this jury guide that you have on the website says that it's the juror's job to listen to all the evidence at trial, and the judge is to deal with legal issues, not the jury.
That's true.
That concerns me about whether I can get a fair trial, because the whole purpose of a trial by jury is to consider issues of law. Otherwise, why do we need a jury? Because
Right.
I've already stated I did the act. I traveled in my automobile on the date in question. I'm not going to
Absolutely
deny
wrong.
that. That's the first thing I would tell the jury if it goes to trial.
Okay.
And I'm
So
going to bring up to the jury the issues of law. My question to the court is how would
here in a
court
second, I'm
have
going to stop you for a second, because you're very wrong about something. Okay, you are very wrong about something. The jury does not decide issues of law. The judge does. The jury decides issues of fact. The jury decides what did happen or not happen. That's what the jury decides. The jury's the fact finder. The judge decides what law the jury listens to. That's just the way it is. And so when you say the jury decides the law, that's not correct. That's, there's no court in the country that where the jury, in this country anyway, where the jury decides what the law is. The judge decides what the law is. And you can look at any court in any state, in any jurisdiction in the union, and that's the way it is. And so the judge, and then the judge will, following the trial, following the evidence portion of the trial, the judge will instruct the jury on what the law is, and then the jury determines whether or not that person, you, did or did not do what you're being charged with. And that's a fact inquiry. And what you're being charged with is driving with license suspended in the 3rd degree, and the jury's going to decide, did this happen or did it not? And if you have issues with the law, they're not fair, you might think this is unconstitutional. I've heard many times people think that, it's not constitutional for a state to require people to get licenses. It is. I've heard that, that there's some, the right to travel is being impinged by the requirements of a license. It's not. All of those things have been looked at by courts much above me, have decided that that's what the law is. And any instruction you're going to get on the law, or the jury's going to get from the law, has all been vetted in front of, courts of appeals and the Washington State Supreme Court. And that's the way it is. But you need to be clear. The jury does not and will not decide the law. The judge will determine that. And what I was going to say to you in advance of that is, you might not get to present. Maybe this is why you think you don't get a fair trial. Some of these legal issues you wish to argue, you might not be able to do that. Probably not. because that's just what the law is. And I know what the law is based on my experience. And I may or may not be the trial judge if it goes that far, but I just know that to be the case. So we're going to stop here for a second because but don't leave because it's at 2:30 and we have some other people coming on at 2:30. We're going to take care of those cases and then I'll come back and speak with you some more. All right.
I understand you believe all that nonsense, but I'm going to have a trial by jury, not a jury trial. A jury trial is 6 people that only consider the facts. And basically juries have been neutered since the rules of evidence have been implemented in the 1936. But this jury is going to hear the law as well as the facts. And I'm just curious. I would like to know how the judge would, how the court would stop me from communicating with the jury.
Well, that's a good question. I guess you'll find out if you take this to trial. But we're going to stop for a minute. I'm going to there's a couple people who we're going to take these cases, and then we'll come back to you. But don't leave. Mr. Merrill, do you want to come on the Zoom call there, please?
Yes, good afternoon.
To answer Dummy's question, they'll tell you to stop it. Stop discussing law in front of the jury. It's inappropriate. And if you fail to stop, they'll hold you in contempt. It's really simple. That's what they'll do.
Okay, so Mr. Blatt, I'll come back to you. So I think when last we talked, you said you wanted a trial by jury or a jury trial. To me, again, that's...
No, I did not say that. I want to be left alone. That's what I said.
Okay. Well, again, that's what everybody wants. So do I. But nonetheless, where you're at right now, you're charged with driving with license suspended in the 3rd degree. And you had made the distinction, I think you had, and correct me if I'm wrong, I don't mean to misstate things. You were making a distinction between jury trial and trial by jury. And I'm not sure exactly what you meant by that.
Well, a trial by jury, which is what we used to have before the passage of the 19th Amendment, when women got the right to vote and therefore got the right to sit on juries. Juries had the right to investigate the crime scene, to consider the law, to nullify. Basically, it was a trial by jury. Now it's a jury trial where the jury's neutered. There's only 6 of them. They're cut in half, and they're not allowed to. They're scurried out of the courtroom every time there's important adult issues to consider, like children, and that's just nothing. That's not a trial by jury. But anyway, I have a dispositive motion right now that might settle everything here.
Okay, we'll set that for a motion hearing, though. We do those on Monday morning. Did you file it in writing?
I'd like to do that. I prefer everything to be in writing. So can we schedule a motions hearing?
We certainly can. But before we do that, I want to talk to you about, it again appears to me, well, we're going to do a couple of things. First of all, I am going to find, based on, there's a police report filed in sector. Based on that, I'm going to find that probable cause exists. And then we're going to set conditions of release, which basically are make all your court dates, don't drive without license or insurance, and don't have any other criminal law violations. Based on our conversation thus far, it appears to me that you wish to represent yourself at trial. Is that true?
I don't understand that terminology. I am myself, so why would I want to represent myself? Only corporations need to be represented because they can't speak for themselves in court. I'm not a corporation. I'm a human being.
So you wish to proceed to trial without a lawyer?
No, I wish to be left alone. That's my only wish.
But yeah, that's true. But that's one that's not going to happen in terms of this case. It is set for trial. The trial will take place. And my question to you is, you have the right to have a lawyer with you during trial. And you also have the right to go it alone, all by yourself. And so those are your 2 options. Which of those do you wish to take?
Well, I have some concerns about being represented by an attorney because attorneys in this state are licensed and franchised to make a living in the plaintiff's courtroom only at the pleasure of the plaintiff, right?
No.
Well,
I
if,
mean, you're under a lot of, you have a lot of unfortunate and incorrect impressions. You really do. And that's really unfortunate. And I'm trying to,
I'm a
let you
plaintiff.
know. And again, you're just wrong about a lot of things. And I'm sorry about that.
Does the plaintiff have the power to disbar the attorney if the
No,
plaintiff-
absolutely not. I don't know why you would think that. That's completely not true.
Well, I personally know attorneys who have been blacklisted because the courts don't like the way they defend clients because they do it too effectively. For example, Lee Eckhart was not disbarred because he never did anything wrong, but he was blacklisted, which means any client he hired automatically lost. And he had to inform each client that wanted to hire him.
I'm not,
he would
again,
lose.
I don't know anything about that individual. I don't know anything about that. You're asking me, I guess, in this court, whether, or just generally, whether the plaintiff, in this case would be the prosecutor, has the right to disbar attorneys. And the answer to that is no, they don't.
The plaintiff is the state of Washington because
Well,
Washington.
in the city of Tumwater, in this case, remember we talked about that.
Yeah, but the city of Tumwater is a subdivision of the state of Washington.
But they can still bring case. So again, what do you want to do for your upcoming trial in terms of an attorney or have one with you or go it alone?
I'm not sure I need an attorney at this point because we'll have to
So
see.
again, that's
the
a binary
prosecutors-
choice. So then from that, I can tell you, you're choosing to go it alone. And have you ever done this before? Have you ever conducted a trial of any sort?
Just look at my record.
That's, again, I can see your record, but that none of it tells me whether or not you've done a trial by yourself before. So, Mr. Blatt, have you ever conducted a trial before by yourself?
I didn't come here to answer questions. I'm sorry.
Okay. Okay. So then I'm going to talk and then we're going to set a date and then we'll
I need to
conclude the
bring
hearing.
I need to bring something to your attention, if I may.
I'm sorry?
I need to bring something to your attention. The United States Constitution at Article 1, Section 1 states that when the state is a party, which is this case, excuse me. You get it for us. When the state, it says in all cases in which a state shall be a party, the Supreme Court shall have original jurisdiction. This is in the United States Constitution. Now, the Washington State Constitution says that a frequent recurrence to fundamental principles is necessary. This is a fundamental principle. When the state is accusing a citizen of a crime against the state can't take the defendant to trial in its own court. That would be a conflict of interest. It has to take it to a neutral court, which is the United States Supreme Court. It says it clearly here at Article 1, Section 1 in the United States Constitution.
So again, I'm going to speak for a few minutes and then I'm going to turn it back to you and we're going to set a date here. And again, I don't first of all, this case is headed for trial. And again, it doesn't appear that you're interested in having an attorney appointed to represent you, so you'll be going it alone. When you have the constitutional right to do that, but you need to know that you're not an attorney. Apparently, you have very low opinion of attorneys generally, and a very low opinion of the system itself. Can you tell Mr.
I have no problem with the law.
Hang on, let me finish. I'm not done yet. The city of Tumwater is going to be represented, and I know you don't like that term either, by an attorney. That attorney is trained in the rules of evidence, trained in the rules of procedure, been through trial many times. And again, I don't know whether you have or not, And so they are experienced in the rules of evidence, which is important. You spoke disparagingly of the rules of evidence earlier. And they have training in that, which again is important. And I'm going to assume you don't. And many of the things that you've talked about, you're incorrect on. Unfortunately, you're just incorrect about some things. And so you're going to be at a big disadvantage when you go to trial without an attorney going it alone. Do you understand this?
Isn't it the prosecutor's job to decide whether I'm wrong on issues? You're supposed to be neutral. The prosecutor hasn't even argued against me, and you're already saying that I'm wrong.
No, I'm trying to, believe it or not, and you probably won't. I'm actually trying to help you, let you know that this is just the way things are going. This is the way that this will happen. I'm not siding with the prosecutor. I'm just saying that this is what, and it's not the prosecutor's job really to decide what the prosecutor and defense, they disagree all the time on what the law is or what should be. And then I'm the one who gets to decide one way or the other. But some of the things that you're saying are so outside the norm that I don't need to hear from them. And I'm trying to let you know that what you think is going to happen and what you think the way things work is simply just not correct. And, I'll go back to that fundamental, I can't speak to the way juries were back in the 19th century. I just know how they are now. And I know that the jury's job in the cases of this sort is to find facts. That's what it is. And the judge is going to instruct them on the law. That's how it is. And the judge is going to determine what's going to be admissible or what's not. And that's just the way the trial is going to go. And I'm trying to let you know that is just to give you advance warning. So when you're in the middle of a trial saying, hey, what's going on here? You just at least have an idea of what's coming. That's all I'm trying to do. And I want to make sure that if you go to trial alone, you're going in with open eyes, understanding that you're at a fairly huge disadvantage. And so, but knowing all that, that's still the avenue you want to take.
You said the jury's job is to decide the facts, but there's no facts to decide because I'm acknowledging all the facts. I'm acknowledging all the facts. I'm not going to challenge them. I'm not going to fight with the prosecutor about what the prosecutor wants to fight about. My issue is the law. And I'm not saying the law is wrong. It's a question of whether the law, this particular law that I'm charged under, applies to me, whether I'm a person within the meaning of the statute. Now, the jurors are taxed to pay legislators to make up laws for their benefit, yet they're not allowed to know what the laws are. Don't you think there's something wrong with that?
Well, I guess my response to that is, I think most people are aware that when you get behind the wheel of an automobile and conduct it in traffic, you need a license. And there are certain things that can happen that can get your license suspended. I think most people know that.
Well, my position is I never had a license, never applied for a license, and I was not engaged in traffic. I was engaged in travel. Traffic is going to be the issue at this trial. And
well, then it'll be up to the jury it'll be jury to determine whether you were in traffic or traveling. That's excellent. And the issue that you said, well, I never had a license, so it couldn't be suspended. I've seen people try this before, and I've never seen it work. License. And so here's what we're going to have to, hang on just a second. Here's what we're going to do today. So right now, trial is set for October 29th and 30th. Jury confirmation is set for October 22nd. You said you had a motion you want to bring. You can, that'll be heard on, what do we do? Yeah. That'll be heard on October 20th. You need to have that filed in writing by October 6th. And the state will have the response filed by October 13th.
Your Honor, if we could please request the defendant's email address so that the response motion can be sent to him, as he's not per se.
Did you hear that, Mr. Blatt?
Not really.
They want it, so you're going to file something, and they're going to see it, They should have the opportunity to respond to it. And they want to get their response to you, and they want to do that through email.
That's fine.
So what is your email?
LeonSblatt@yahoo.com. LeonS as in Sam, BLATT.
You get that?
I did, thank you.
All right, Mr. Blatt, I think that's it for today. And then at that particular time, the judge, whether it's me, whether it's one of the other judges here, I don't know.
How many judges work in this court that could be on this case?
4.
4, okay. Can I have their names?
Sure. There's Kayla Wilcox, Brett Buckley. You already know my name. And then there's a commissioner named Paul Wool. It's all on the district court website. You can just go look at it.
Okay. Thank you.
And my guess is that judge, whoever hears the motion, is probably going to have a conversation with you again, or at least try to, about the concept of representing yourself and the disadvantage. And again, I know you hate that word. I'm sorry if that offends you in some way, but or going to trial alone without the assistance of an attorney. That's just.
I never expressed hate for any statute or attorney or wording or the.
I don't say that. Again, I'm not suggesting you are. I think that, or if I did use that term, I apologize. I just think that, I'm spending a lot of time with this because I just think you're under some misunderstandings of a lot of real basic points. And, in terms of we're here in district court, the state of Washington, you want to talk a little constitutional law, state of Washington Constitution sets superior courts of courts of records. It's also in the Constitution that they can set and create such inferior courts as, by statute through the legislature. The legislature has done that. They have established this level of court through Chapter 3 in the Revised Code of Washington, if you want to look there. There's also a mechanism in place where district courts can contract with municipalities to provide court services. All this stuff has been litigated through the Court of Appeals and the Washington State Supreme Court. And again, it's just pretty standard stuff. And I've tried to spend some time explaining it to you. Unfortunately, I don't think I've been very successful. I'm sorry about that. I wish I was more successful, but you can research all that out. And I guess when you talk about one thing I will go back to that I should have said earlier, when you say the jury, you want to argue the law to the jury and shouldn't they know the law and so forth. A lot of that happens in the Court of Appeals and the Washington State Supreme Court. Again, I'll instruct the jury or whoever the judge is, whether it's me or one of my colleagues, will instruct the jury on the law. The jury will decide the facts and then apply the law as I instruct them to it. Now, if I'm wrong about the law and you turn out to be right, all that's handled at the appellate level. You would file an appeal if you're convicted, and then you would, the court, first superior court would look at it and see if I made a mistake on the law, or you're right on the law, and then it keeps going up all the way to the Court of Appeals, and then eventually to the Washington State Supreme Court, all they may or may not choose to take it. And so that's where the issues of law are decided.
Everything you just said about the evolution of the law is true. However, the Washington State Constitution says that a frequent recurrence to fundamental principles is necessary for a free state. That's what it says. So that means we eventually get so convoluted to oppress citizens of the state that we have to go back to fundamental principles.
Right. And again, I do want to address your last thing, in terms of oppression. Again, let's remember what we're talking about here. And that is your license was suspended and you were alleged to have been driving. I know you have to say, well, you were traveling or whatever. And that's just, again, the only issue is, were you conducting an automobile and was your license suspended? And that's it. That's what this case is all about.
An automobile is different from a motor vehicle, and I believe the statute refers to motor vehicles. Motor vehicle.
Yeah, motor vehicles encompass a lot of things. A motor vehicle can be a motorcycle, it can be an automobile, it can be, so, and I think that that's generally pretty accepted that an automobile is a motor vehicle.
No, a
I
motor
mean, I
vehicle,
believe that it is,
a motor
unless
vehicle
it runs by, unless it's the
Motor-
Flintstones where they just run on the ground, then that's not a motor vehicle, but I'm joking, perhaps I shouldn't be.
a motor vehicle is a specific legal term in commerce. It's a business machine, like a truck, a taxi, or a bus that makes its business on the publicly funded roadways, which it does not have a right to do. A person
see,
who,
You, again, in Washington, and again, a motor vehicle includes a car. It does. And again, where do you get your driver's license? You go to the Department of Motor Vehicles, the DMV. That's where you get a driver's license for cars. And
Well,
so
when
it
you-
makes sense that, and again, I don't want to, we're going down a rabbit hole that was really not productive for either one of us, frankly. But, and again, I will just tell you that a motor vehicle includes automobiles within the terms of this statute in this state. It just does. And you
I'll
can
just
argue
address, I'll address this in my brief.
otherwise, but you're not going to be successful.
I'll address this in my briefs and my motions, but of course, the prosecutor and you will just pretend like you haven't even read it, like it. I've been through this
Well, I
many
don't-
times. Been through this many
No, I
times. and
can't
judges-
speak. Okay, I'm going to stop you again. I won't speak for the prosecutor, but if it's me, I'll read it. I'll read all of it.
But my experience has been, I'm sorry to say, to accuse you, but my experience has been that judges will just pretend that they haven't read it. They'll say,
Oh.
I read it and I found it's not correct. But
If
they
you
never
can-
talk about, they never
You
talk
can-
about the issues.
Again, I don't want to talk about things that haven't even happened yet. So maybe it'll be me and then we'll see what happens. But do you know when you need to get your brief due? Your
October
motion?
6th, October 6th,
Yeah.
and the response by October 13th.
And we'll all reconvene on October 20th and hash it all out. Whether it's me or one of my colleagues, I don't know.
Okay,
That'll conclude the hearing for today.
thank you.
You're welcome. So Mr.
251160. That is, I'm sorry, Ali Maurice Tahiran versus, Ali Maurice Tahiran versus David Portillo, Joe Rodriguez, and others. On behalf of Tahiran and Tahiran,
Yes, this is Ali, present.
good morning. Do I have someone here on behalf of first David Portillo?
David Portillo's here, present.
Good morning, sir. Do I have someone here on behalf of Joe Rodriguez? Anyone here for him? No? All right. Mr. Tahiran, tell me why this eviction is being sought.
Yes, so this is based on unpaid rent for multiple months. It would be June, July, August, and now September. There are also damages to the property, which includes the carpet. Also, there was never a deposit or agreement for an animal. That's besides the point. Damage to the yard, the grass, and also
Okay. How much is the monthly
unkept
rent?
dog drippings. Yep.
Mr. Tahiran,
The
how
monthly
much
rent
is
is 1,100.
1,100. Is there any subsidy on it?
There isn't.
Okay. How much did they pay any for June?
There's been no payment.
No
The
payment for
total,
June, no
yeah,
payment for July, no payment for August?
and now we're into September, and of course there is no payment yet either.
Okay. Was this
May
your
I,
property?
yeah, and may I note technically what the late fees are per the lease agreement?
Mr. Tahiran, you can't recover late fees in an eviction hearing. That's something you
Okay,
bring in
no
small
problem.
claims.
Okay,
You got non-payment. Non-payment is your easiest ticket to win your case. So let's get to it. It's
no
11.
worries.
They didn't pay for June, July, and August. Great. Is it a CARES Act property?
No, it is not.
What day did you give them the notice to vacate?
That was done on August 8th.
All right. Good morning, Mr. Portillo.
Good morning.
Thank you for being with us. All right, Mr. Tahiran is here. He says that he's the landlord for the lease and that this case is, what about non-payment? He said that under the lease, you and your roommate are responsible to pay $1,100 each month. Is that correct?
Yes.
Okay. And he said that rent hasn't been paid for June, July, August. Is that correct?
Oh no. June, I didn't pay. I wasn't able to pay.
Okay, so
We
June
were
not
trying
paid.
to, we were trying to get, on an agreement, payment plan.
All right. Did you pay anything at
July,
all for June?
we had an agreement that he
I
had
know you
fall
had an
back on.
agreement, but Mr. Portillo, you had a lease that said you were gonna pay.
Yeah, yeah,
My question
but
is, did you actually give the landlord any money for the month of June? Yes or no?
no.
No. Did you give him any money for the month of July?
Let me check my,
Because here's the thing, I give you
give me,
credit for everything you actually paid him.
okay, give me,
Right? So if you made a partial payment, I'll reduce that from what it is, but right now he's
one
got
second.
$3,300.
One second, 1 second. I have to go into my phone real quick, get into my, you mind if I do that real quick?
Mm.
1 second, I'm sorry.
Mr. Portillo, do
Head it
you
up.
know, as you're looking, do you
I-
know that you made payments?
I got on my payment, on my credit card that I always pay them with, so I'm trying to get the dates right. I don't want to say anything wrong.
Okay.
Judge, may I make a critical point while he's checking? Joe Rodriguez, I'm dropping the eviction case for him. I'm pursuing with David Portillo only. Joe and I have come to an agreement and communicated effectively for payment plan, and he has executed that. And so I'm dropping the eviction case for Joe Rodriguez, but I am pursuing with David Portillo. When you
Okay,
said
so
you and your roommate, I just wanted to
Mr.
make sure that was
Tahiran,
clear.
if you've been made, how much money,
Your Honor.
and no, Mr. Portillo, just a moment.
Yes, I did.
Mr.
I did.
Tahiran, Mr. Tahiran, I'm asking a question. How much money has Mr. Rodriguez paid you?
He hasn't paid yet, but we have a payment plan in effect, and he's made payments in the past when he's been behind. He's been there for 5 years, and he communicates effectively, and he always corrects the late payments. Unlike David, who has not communicated whatsoever.
Is the lease joint and several?
They're separate lease agreements. The
So why
lease
did you put
agreement,
them together?
I because they both lived there and they were both unpaid at the time. And they have separate lease agreements, and David's lease agreement has been turned in as a file that you can review.
So you gave me the lease for David, and you're
Mhm.
dismissing the case against Mr. Rodriguez.
Yes, ma'am.
So you just
Your
tried to
Honor.
get 2-in-1 when you filed it the first time. You should have filed 2 separate cases and you didn't.
They were both under the same address, and when I was filling out the paperwork, I
That's my
thought
point.
that
Mr. Tahiran, lots of people live at the same apartment complex. They're not all part of a suit. You should have filed 2 separate lawsuits and you didn't. You filed one, but it worked out in your favor because it turns out the one you didn't actually file on, you were going to dismiss it anyway. Right?
whatever is most effective for court, we can move forward with the way it is if you prefer that.
It's
But
what's
I would,
legal, Mr. Tahiran. If your contract that you're showing me, which you submitted, you're right, the contract only has Mr. Portillo's name on it. So if you wanted to sue the other guy, that would have been a completely separate lawsuit. But you got 2-in-1.
correct. They're both
All
at
right.
the same address.
Like I said, and you dumbassed your way out of it.
So Rodriguez has been removed.
Yes, please, Your Honor.
Right. Have you done that in writing, or are you making an oral motion to me right now to remove Mr. Rodriguez?
It's purely an oral motion.
Your Honor, may I say something?
Yes, Mr. Portillo. Did you find that you made any payments?
Yes, I made a $850 payment on July,
You made how much in July?
$850,
$850?
ma'am. Yes, Your Honor.
Mr. Portillo, it's
Also for
breaks up a lot.
August, I was out of my room in August, forced out of my room in August. So there's a new tenant that's living there already.
Okay, Mr. Portillo, let's start there. Do you still have keys to this unit?
What's that?
Do you have a key to get into the apartment?
There's no key. There's a code on the door. In and out.
All right. Are you still living there?
I'm out of the house already.
Mr. Portillo, it is very hard to hear you. You're moving the phone around. I cannot
I'm
hear
sorry.
you.
No, I'm out of the house already. I'm living with a friend.
When did you move out?
In August, when he gave me I was forced out in August when he told me August.
I need a date, Mr. Portillo. What
Well, when you
day?
gave me August 8th, when you gave me the notice.
And did you move all your stuff out?
Yes, Your Honor.
You said you didn't have a key?
No, there's no key to the house.
How did you access the building?
It's the house. And there's
As
a
a tenant,
code.
how did you get in and out of your house when you were living there?
There's a code to the front door.
Okay, and did your code stop working?
No,
Mr. Portillo?
it still works. The code still works.
So then why do you say you were forced to move out?
Because somebody's already moved into my room.
Mr. Portillo?
He signed a new lease.
You see it
Somebody
logically
else.
what I'm having trouble with? Did you show up and all your stuff was boxed and out of your room, or did you
No, he told me,
voluntarily move out?
I volunteered and moved out.
You
He
moved
told me
out,
to,
all of your own
he told
volition.
me, yes, he forced me out. He told me, sheriff's gonna come out and force me out and he told me to be out already.
Okay.
So I got out.
Mr. Portillo, this is so important to me. Do you understand you're under oath? Right now in court, are you swearing to me under oath that you moved out and all of your belongings were gone on August 8th?
Yes, ma'am.
That's it. Mr. Tahiran, is that correct? Did Mr. Portillo?
He's actually in the house now and has never left, and I have multiple witnesses
Well,
to
I
that. I'm talking right now.
I'm feeding the cats. I'm out of the house. I'm just here to feed
He's
the
actually
cats.
in the house as we speak. It's
Yes,
been verified.
All right,
One
Mr.
person
Tahiran,
at a
Mr.
time.
Tahiran.
I will wait until I can
Mr.
continue.
Tahiran. Mr. Portillo, where are you at right now?
I haven't seen this. This is good. He's actually in the house as we speak. He is. I'm out of the house, Judge, from the house. I don't know, but that's funny.
I'm actually here because one of the other tenants, this friend of mine, he's in Dallas.
Judgment for the
He has
plaintiff,
cats here.
$3,300 plus cost of court. Either party can appeal. It'll be $1,100.
But I have.
Judgment for the
another tenant.
plaintiff, $3,300. Both parties can appeal $1,100. Mr. Portillo,
Thank you, Your Honor.
please call an attorney. Mr.
Can
Tahiran,
you-
please call an attorney. Both of y'all, follow the law.
Okay, say that again.
All
What
parties
was
are
the
excused.
what was the final? What was
It's
the
$3,300. June, July, and August. Didn't give him a dime for September. You can appeal.
was out for
Mr.
August.
Portillo, please understand that if you're telling me you're not
Okay.
living someplace, if you're physically in possession of it again, destroyed your credibility.
But
All right?
but there's a
All-
tenant here that.
Thank you, Your Honor.
Mr. Portillo, please go contact a lawyer. If you have proof that
Okay.
you moved out, you should appeal. But
Okay.
don't tell me you've moved out while you're calling from that
Well,
unit.
I have text messages and everything
All right.
showing that
All
I've got
parties
my
are excused. Please, please, please look into
Okay.
your options, y'all. Okay.
Thank you, Your
All
Honor.
right. All parties are excused.
This is it. We are either setting this case for trial today or it's being resolved today.
My client suffering from pink eye.
Pink eye?
I don't feel well.
Go out in the car. I was convinced by staff that you actually can speak English. Taxpayers are not going to pay $160 an hour. We're not doing this. What's your name, sir?
I am an interpreter, Your Honor.
Oh, yeah.
Gonzalez.
Okay.
He's talking to the attorney. He says he doesn't need me. He doesn't.
I apologize for that high production value. That was entirely Zach's fault over at Law Nerds Unite.
Know why they told me that he only relates to one for the first appearance. I don't know if you want me to stay.
I want you to stay. I want you to bring that defendant in with his lawyer. Tell him the judge would like to talk to him.
Yeah, they are talking in the.
I'd like him to come in here and talk to me. Okay? Can you tell him to come in here? Or do you want me to tell my court officer, do this for me? Stay right there. Go tell the lawyer and the defendant, what's his last name?
Delante Gonzalez.
Sloanthi Gonzalez. Bring them in here. And his lawyer. And the file. Lisa?
Good Lord, Jacqueline. Best of luck to you. Please do not spend any money on a super chat or a membership.
Yes,
Not a happy camper, right?
I know.
Just so you know.
I know.
These are talking to Parcel about.
The victim's here also, just so you know.
I want all the interpreter fees added up on that case. Do you understand me, Lisa?
Yes,
Good.
I'll check.
Thank you. Put them in the file, please. And I will have a little conversation with this gentleman. Mr. Good. I'm going to wait about 30 seconds.
Yes.
Can you come up here, Mr. Interpreter? Mr. Crawford, come on up with that file.
Want the victim in now?
I want the victim, I want everybody. Give me that. David Istalar Gonzalez, 25W86565.
Good morning, Your Honor. Mike Hillcoff, representative of the defendant, stands to my right.
Name,
David Istalar Gonzalez.
your name.
Mauricio Fernandez de Cordova, Your Honor.
And you are a certified interpreter in Spanish, correct?
I am, Your Honor.
Okay. And your name, Mr. Lucas.
My name is Carl Lucas.
What did you tell me when you came in the courtroom and I asked who you were?
Was an interpreter for this case, Your Honor. Mr. Gonzalez told me that he doesn't really get me. That he, I call it perfect tonight. But yeah, the request was for the first appearance.
Did you tell him that? Yes?
Yes.
You told me you needed an interpreter.
Yes, I can answer from all of you.
The whole courthouse has been telling me that you were capable of carrying on conversation with them. I don't know why you're smiling. No. When it's your turn to talk, I'll tell you. The entire courthouse has been telling me for weeks that you're able to converse in English. You told me you needed an interpreter. If you want to play a game, I'll somehow figure out a way to give you permission to put a badminton court out back here, and you play out there. Go have fun. You don't bring interpreters in here because you want to be a wise guy. You don't come into a courthouse and act like you need an interpreter when you don't need an interpreter. Got it? You got it? How disrespectful. How incredibly misleading and disrespectful, Mr. Istalar. You know the good news about this? This upsets me. I'm not going to treat you worse, but you will pay for every nickel that the court's incurred and interpreted. Do you understand this? You want to play another game? Figure out how much his fee is going to be today. I'm going to release the interpreter, Lisa, please. I want that included as well. You guys take your time. Go back and see, go over the report. Maybe there's some kind of an explanation that he's been taking English classes since the time he was arraigned back in July, and suddenly, he's capable of speaking English. Maybe there's some kind of an explanation for all of this. I sure hope so. You've been a smug guy with me from the beginnings, fellas. You want to be smug? You can be smug. This is not the place to be small. This is serious business. This is very serious business. Go out. You still look like you're smiling to me, and I just can't even imagine. I cannot even imagine somebody looking smugly at the judge with a smile on your face after the judge just discovered, after bringing in interpreter after interpreter, that suddenly you wise up and you admit that you can speak English. I watched him say, "Follow me," and you didn't even hesitate. My court officer here, half an hour ago, 20 minutes ago, were you in the courtroom? He said that, and it was abundantly clear, but it's been kind of clear before. But see, I find it so outrageous and outlandish that somebody would look a judge in the eye and tell them they need an interpreter if they don't need an interpreter. I'm going to give you the benefit of the doubt. I hope you enjoyed yourself. I hope you got a lot of money too, because these interpreter fees, they're not charging $22.12 an hour. Go talk to him, Mr. Crawford. Sir, you're released. Thank you very much. My sincere apology that somebody forced us to contact you and bring you in here when you had nothing to be here for. Go take your time. Here, give him this, please. I need to get off of this bench right now. Keep smiling, Mr. Istelar. Keep smiling. I hope you're enjoying yourself. People against David Istelar Gonzalez, 25W836565.
Morning, Your Honor. Michael Crawford, representing the defendant. Sir, please state your name for the record.
Name. Your client pled to attempt MDOP back on August the 6th. The prosecutor dismissed the malicious destruction of property charge. I ordered a pre-sentence report. Have you had the opportunity to review the report with him, and are there any material additions, corrections, or deletion?
I've had the opportunity to review the report with my client, Your Honor, and there are no material additions or deletions that we requested at the time. I find that we can apply this recommendation, and we ask the court to adopt it.
Mr. Lucas, your name?
My name is Carl Lucas.
All right, so I'm going to listen to what they have to say. They're urging me to adopt the recommendation. I'm going to go on to Mr. Istelar Gonzalez, and then I'm going to ask you if you have anything to say, okay?
Yes,
sir,
sir.
would you like to say anything?
Oh, you're speaking to me?
No, I'm asking Mr. Istelar Gonzalez.
No.
Thank you, sir.
Is there anything you would like to say, Mr. Lucas?
I did submit a letter to the court demonstrating the damages that were done to my vehicle, and I paid to have those corrected. I just want reimbursement.
How much were the interpreter fees, Lisa? And I want you to estimate how much we're going to pay that gentleman today. I think it was $160 an hour. I don't know.
They charge $160 an hour with a 2-hour minimum and an $80 travel fee.
So that's $400 on my math.
Yeah, he's been here 3 times, so I figured it to be $1,200.
$15 months probation. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. Change your address, your place of employment, or home telephone number, you must notify probation. You have to report as directed. You're to attend the anger management program with follow-up. You're to obtain and maintain employment, provide proof. I see that you are working, making $2,000 a week. You're not to have any contact with the victim, Carl Lucas. You cannot write, phone, see, text, email, or communicate with him in any way or have anybody else do any of those things for you on your behalf. You're not to possess firearms. You're not to possess dangerous weapons. You're to serve 4 days on the court work program. There's a $35 a day charge for that for a total of $140. You're to pay fines $100, costs $100, 75 victims' rights fee, $50 justice assessment. So fines and costs are $325. You have probation fees of $300, bring the total to $625. You have attorney fees in this case of $100, bringing the total Let me just do my math here again. $325, $625, $725. You have court work program fees of $140 for a total of $865. I want to make sure that I'm getting the fees right, Lisa. You're to pay restitution through the court to the victim, Mr. Lucas. You're to pay through the court in the amount of $1,265.50. That brings your total to $2,130.50. You're to pay interpreter fees of $1,200. Your total here amounts to $3,330.50.
This is Lab Matt's
If you
fault, by the way.
violate, your probation could be revoked. You could be incarcerated for 45 days. You have 21 days to appeal. You have 14 days to apply for a court-appointed lawyer for purposes of appeal. If you violate, you're going to get 45 days, or you can get 45 days. Do you understand?
Yes.
Do you have all of this to pay?
That would mean a payment plan.
I'm not going to be very patient with you. Okay? How much do you have today?
$100.
I'm sorry?
$100.
You make $2,000 and you're single every week and you don't have more than $100?
That's the relatives outside.
I hope you've enjoyed this little experience. I cannot believe you did this. I know you're sitting there smirking again.
It's not going to be.
Pardon me?
It's not going to be.
Go ahead and appeal. And I hope the record's abundantly clear. Because you've had fun in the system. You have no respect for the system. Go ahead and appeal. Like I'm afraid. Give me a break. Go ahead and laugh all you want. You're going to pay $100 a week. And if you need more time, you're going to have to come in here and talk to me. Okay? Let's all have a good laugh. Let's all have a good laugh with Mr. Installart Gonzalez. Beginning September 15th.
I'm having a good laugh.
$100 a week. Thinks he's funny, huh? You better show up for everything, Mr. Gonzalez. You don't. You go to jail.
Like a
That'd
clown.
be funny, huh? Have a great day.
Just to be clear, his first $100 payment is due today, correct?
That would
Yes.
be funny.
So they're going to accept check
Yeah, we'll accept the check
or credit card.
or credit card, whatever you want. You get points.
Look at your card, look at it.
See what? What did he say, Mr. Crawford?
What you say, Mr. Esquire?
Come on back here.
Come on back here.
That's what I said. There it is. Right?
You're not going to see me in court.
Oh, no.
No, you get to go in front of another judge and play with them for a while. How's that? Enjoy your journey through the criminal justice system. Mr. Lucas,
Yes, sir.
I'm sorry that you had to listen to all of that. I'm just amazed that somebody, I don't know what's going on anymore, to be honest with you. But that was, I'm not surprised that his conduct elevated to the point that it did on the date of the offense. Let me just put it there. Have a great day, sir.
Yeah,
Good
thank
luck
you for
to
your
you.
time.
Thank you very much.
Good morning. May I have your name and date of birth? Donald Fortney, 7/24/1960. Thank you.
This is Hector Camclip's fault. It's short.
We are here today on two different cases. They're both probation violation warrants for violating terms 3 and 5 of your probation. I will appoint you an attorney on both of these cases. I am setting a probation revocation arraignment hearing on September 10th at 8:30. That's in the downtown Superior Court. I am going to issue a secured bond in both cases in the amount of $250. So total bond of $500. If you do post bond, I am ordering that you not possess any weapons, drugs, or alcohol, and you must contact probation within 72 hours of your release. All that's going to be in your paperwork. Do you have any questions?
Yeah, I ain't done nothing wrong. Nothing. My probation officer knows I don't have a phone. I'm homeless, and I can't get no help in nature, but threatened by the police. My third is all stowed away. They killed my dog. What have I done wrong on this probation stuff?
Sir, the issue is that you've been on probation and you've not maintained consistent communication with your probation officer.
I'm in nature. She's here. She wouldn't come there and see me.
So, sir, this is a discussion you have to have with your attorney.
Yeah, I go to jail for nothing. For nothing.
It's not for nothing, sir. You're here today on probation violation.
But I didn't do nothing wrong.
Sir, part of your probation is that you have to maintain communication with...
How about you when they steal my phone?
Sir, this is something that you're going to have to talk with your...
Yeah, I get punished for nothing every freaking time, Judge.
At this point, it's not appropriate to yell in a courtroom.
We're not done.
Mr. Fortney, let's go ahead and bring you back to the podium, please. So, sir, hold on. This is not your time to talk. I appreciate that you're frustrated by the situation, but how you just acted as you left court is not appropriate.
I'm sorry.
Okay? So you need to talk with your attorney about these allegations. I'm appointing one to represent you. I understand that you're frustrated, but we do not yell, we do not throw things, and we do not disrespect the detention officers as you're leaving court. Another judge could hold you in contempt for such actions in the future.
Well, give me 50 years. I don't care.
Today.
Give me all the time you want.
Take him out of the courtroom, please.
Hell, man. Throw me away in jail. I don't care. I ain't got it.
Becky Gallo to the podium.
All right, there you have it. That went longer than I expected because we had an emergency SovCit in the middle of stream. Always good to have an emergency SovCit. It was beautiful, top to bottom, from Lanice Bryant to I Did Nothing, top notch, solid gold. You're welcome. Thanks for coming out.